Hi, my name is Allison Heller, and I'm an attorney at the law offices of Tony J. Tyer. Today, we're going to talk about joint ownership. Many clients who I meet with have questions about joint ownership of property, and specifically, whether holding assets jointly or adding another individual to their property is a good way to pass down property upon their death. In this video, I'm going to talk about the pros and cons of joint tenancy. I'm going to start by explaining how joint tenancy works. Joint tenancy is a way of holding title to property whereby all joint owners have equal, undivided interests. Both real property as well as financial assets can be held in joint tenancy. Under joint tenancy, joint owners cannot transfer, encumber, or alienate their individual interests in the property. Now, the biggest advantage of holding property in joint tenancy is the right of survivorship, which means that upon the death of one joint owner, title to the asset automatically passes to the remaining joint owners without the need to go through probate court. However, there are some major drawbacks to holding property in joint tenancy. For one, if all joint owners pass away simultaneously, then the result would be multiple, costly and time-consuming probate proceedings for each joint owner. Another serious issue with holding property in joint tenancy is joint liability. Because all joint owners share an undivided, unified interest in the property, if one joint owner gets sued, then the entire property is subject to attachment by that person's creditors. And finally, adding another person to your property as a joint tenant during your lifetime creates a major tax disadvantage, and that the other joint owner would not be eligible to receive a full step-up in basis when they inherit that property upon your death. As a result, that person will get hit with substantial capital gains taxes if and when they sell that property. Before adding someone to your property as a joint tenant, you should consider consulting with an estate planning attorney to discuss setting up a living trust to better protect your assets. If you'd like to learn more about living trusts, please visit our website at www.tyrelawgroup.com. Losing a loved one is always difficult. On top of coping with grief, many people become overwhelmed by the numerous obligations and tasks associated with settling their loved one's affairs. Oftentimes, people don't know where to start. In this video, I'm going to discuss some of the most important steps to take when someone passes away. The first thing you should do is notify those persons who were close to the deceased individual, such as family members, friends, and their employer if applicable. You may also need to make arrangements for the care of children, pets, or any other individuals under the deceased person's care. You will also want to locate the deceased person's important papers, including any estate planning documents they may have, and any pre-arrangements they have made for funeral, burial, and/or cremation. Additionally, you should immediately take actions to secure the deceased person's home, vehicles, and any other property to ensure the safekeeping of their contents. You will also need to contact the funeral home, mortuary, or crematorium to coordinate the disposition of the deceased person's remains. Now, if the deceased person has made pre-arrangements for funeral, then you'll want to follow these during the time. You will also want to request several copies of the death certificate, as you will likely need these down the road to gain access to and transfer that person's assets. Finally, you should consider scheduling an appointment with a qualified estate planning attorney once you've had the time to grieve and take care of the initial steps. The process of administration will vary depending on whether that person had a trust, a will, or no estate planning documents at all. Accordingly, it's crucial that you consult with an experienced professional to ensure proper administration of the estate. If you'd like to learn more about post-death administration, please visit our website at www.tyrelawgroup.com. Many pet owners worry about what's going to happen to their animals if and when they pass away. Fortunately, California law allows for the creation and establishment of something called a pet trust, which allows pet owners to legally set aside funds to be applied towards the lifetime care of their furry, feathery, and scaly family members. In this video, I'm going to talk about how these special trusts work. A pet trust is typically created as a subtrust, which branches out of the main trust agreement. But it can also be designed as a standalone trust, or even created through a will. Now, because you cannot distribute funds directly to an animal, a pet trust directs certain funds to be set aside in a separate trust account to be managed by a trustee for the benefit of the animal or animals for the duration of their lives. In order to create a valid pet trust, the following requirements must be met. 1. The trust must be created for the benefit of a domestic animal or pet. 2. The trustor must designate a person to serve as trustee of the trust. 3. The funds must be exclusively used for the benefit of the animal. And 4. The trust must terminate upon the death of all animals for whom the trust was created. Once established, funds from a pet trust can be used for any and all items or services that directly benefit the animals, including but not limited to food, medication, veterinary care, toys, grooming, bedding, boarding, and other comfort items. If you'd like to learn more about how you can incorporate your pets into your estate plan, you can contact our office by visiting our website at www.tirelawgroup.com.
Hello, my name's Tony Tyre and I'm an estate planning attorney. I do a lot of advertising and a lot of search engine optimization on my website. And what I've heard from many people is that the future is all about video content. And for my team, we've thought about doing this for a couple of years, but just never were quite happy with the content that we created ourselves. And then a friend introduced me to Nelson, and I have to say he really is the best thing that could have happened to my firm regarding video content. We've made commercials, we've made videos for YouTube, and he really does a lot along with his team to make you feel really comfortable in front of the camera. I shot videos and then my two associate attorneys shot videos, and initially they weren't really so happy that they had to do so, but let me tell you, we were all really happy with the experience while shooting and even more happy with the video content once we actually received the final product. So in my opinion, I strongly recommend hiring Nelson and his team, and I don't think you'll regret it. Hello, my name's Tony Tyre and I'm an estate planning attorney. I strongly recommend hiring Nelson and C7 Media Art for all of your video content needs. For my team, we tried creating video content on our own and we just were not happy with the content. However, working with C7 Media Arts and Nelson really took our video content to the next level. Everything looks extremely professional. The process was extremely easy. And as a result, I definitely recommend their services.
Hi, my name is Allison Heller, and I'm an attorney at the law offices of Tony J. Tyer. Today, I'm talking with Natalie.
Is there such a thing as the reading of a will?
So this is a really common question that we get asked a lot, because a lot of times in movies and TV shows, people see this whole dramatic scenario that plays out. If somebody passes away, the lawyer gathers all the family and friends together and, by candlelight in a dimly lit room and reads the provisions of the will. But in reality, it's really more of a formal process, and there really isn't such a thing as a reading of the will. Instead, what will typically happen is the family members actually will notify the attorney and maybe hire an attorney to help them administer a person's estate. And at that point, they receive notice in the mail, the family members and beneficiaries, more of a formal notification letter or some kind of notice of hearing in a court document. But really, there's no kind of gathering like that.
If I have a trust in California, can it hold property in other states?
Yes, it can. So once the trust is established in California, you're able to freely add and remove property throughout the United States to it, and the trust has full control over it. Typically, it would be administered, however, in the state that the trust was formed in.
Can my California trust hold property in a foreign country?
So this is a question that comes up a lot, and unfortunately the answer is no. If you create a trust in California or within the United States, it can only hold property located within the United States. What that means is if you do hold property in another country, you'll want to consult with an attorney within that country to ensure that you're in compliance with local laws there, because trusts here aren't recognized outside of the United States.
Instead of going through a lawyer, can't I just create my own estate plan through a legal document website online?
So this is technically, the answer to that is yes. So there's no requirement to work with an attorney to create an estate plan. However, it's typically advisable that you do go through a qualified estate planning attorney. A lot of these websites like Rocket Lawyer and LegalZoom offer these new estate planning services where they offer low fees to create your own trust. Now the problem with that is oftentimes if you're going through these websites, you don't have the benefit of working with an actual attorney. So in many cases, you're kind of designing your own trust and kind of guessing things. They're using fill-in-the-blank kind of templates. And you might end up designing something that really isn't suitable to your needs and really isn't the best fit for your asset situation. Because you're not really getting the benefit of that legal advice, you could end up with an estate plan that really is not proper based on your assets. So even though, yes, you can technically go through these, and a lot of times people are drawn to them just because they typically can be done at a much lower cost, it's always preferable to go through an attorney so that you're getting the best legal advice possible.
Well, thank you, Allison, for all the information you gave me today.
You're welcome, Natalie. And if you'd like to learn more about estate planning or anything that we talked about, then you can visit our website at www.tyerlawgroup.com. You can also like and subscribe and follow us on social media.
Hello again, everyone. My name is William Mason from the law office of Tony Tyer, and today we're going to be talking about no contest clauses in California. So what exactly is a no contest clause? A no contest clause is a provision found within a will or a trust that penalizes a beneficiary for challenging the document in court. Generally, the prescribed penalty is the disinheritance of the beneficiary that brings the challenge. A couple of questions I commonly receive are, 1, should I include a no contest clause in my documents? And 2, is a no contest clause actually enforceable? My answer to those questions are yes, and it depends. While it's important to include a no contest clause in your documents in order to, for example, deter frivolous challenges to your estate plan, Per the California Probate Code, no contest clauses are only enforceable in limited circumstances. Specifically, 1. Direct contests brought without probable cause. 2. Pleadings to challenge a transfer of property on the grounds that it was not the property of the transferor at the time of the transfer. And 3. The filing of a creditor's claim or prosecution of an action based upon it. In most cases, we're primarily concerned about the first item, however, direct contests brought without probable cause. So the question then becomes, why would a beneficiary challenge the document in court? Often, challenges to the document are centered around the validity of the document or the validity of changes made to it, and usually these challenges are based upon allegations of things such as fraud, duress, undue influence, lack of capacity, and other similar allegations. Because these allegations are basically direct contests that challenge the validity of the document, is the beneficiary that brings the contest disinherited per the document's no contest clause? That's the question. Well, not necessarily. These challenges must be brought without probable cause. So then the next question is, what exactly is probable cause? Fortunately, the California Probate Code defines that for us as well. Probable cause exists if, at the time of the filing of the contest, the facts known to the contestant, meaning the one bringing the challenge, would cause a reasonable person to believe that there is a reasonable likelihood that the requested relief will be granted following a full investigation of the contestant's claims. So, for example, if your brother convinced your mother to make a change to her trust that resulted in your disinheritance, and she was suffering from dementia, Alzheimer's, or some other debilitating mental condition when she made that change, you may have probable cause to challenge the amendment, and her no contest clause would likely not apply to your particular challenge. But if she amended her trust and reduced your distribution simply because she likes your brother better than you, your decision to challenge that change may result in the clause's enforcement and thus your complete disinheritance. And that was really a brief summary of no contest clauses in California. I hope you enjoyed that video. If you want to see more, like, subscribe, comment. Thanks again, and we'll see you next time. Bye-bye. Hello again, everybody. My name is William Mason with the Law Offices of Tony Tyer, and today we're going to be talking about Proposition 19 and its effect on estate plans. Back in November of 2020, the California voters approved Proposition 19. Ultimately, Proposition 19 replaced Propositions 58 and 193 and significantly changed the method by which counties assess property taxes. Now, Proposition 19 is fairly complicated and its complete substance and nuances are far too much for this particular video. However, I'm going to explain to you some of the basics and how Proposition 19 affects your estate plan and the transfer of wealth. Let's say you have a trust, and let's say that you own two homes which are also in trust, your primary residence and a smaller rental property. Prior to the implementation of Prop 19, following your death, your children would receive the two properties and receive them both with the same property tax basis you enjoyed while living. Those properties could then be held by your children indefinitely, passed to your children's children, and by your children upon your children's death. Try saying that 3 times fast. Post Proposition 19, however, when your kids receive the two properties, the rental property will be reassessed no matter what. So your home is okay, but the rental will be reassessed. And your primary residence will also be reassessed unless, 1, your kids move into the residence, and 2, your kids make your residence the primary residence, and 3, file the appropriate paperwork to claim the reassessment exemption with the county in which the property is located within 1 year. That's a lot of stuff to think about. Does this mean that you shouldn't put your property in trust? Of course not. Your kids will still enjoy a bevy of other tax benefits by inheriting your property, such as step-up in basis, for example, which we can discuss in another video. However, the passage of Proposition 19 has undoubtedly made it much more difficult to create intergenerational wealth, as property tax reassessment based upon current property values may make your children's retention of several properties cost prohibitive, thus requiring the sale of real property rather than allowing it to be retained and passed on to future generations. That's the brief summary of Prop 19. I hope you enjoyed it. I hope it made sense to you. And if you enjoyed that video, we can do another one in the future. Like, comment, and subscribe, and we'll see you soon. Bye-bye. Hello everybody, welcome back. My name is William Mason from the Law Offices of Tony Tyer, and today we're going to be doing a brief overview of small estate affidavits. Occasionally, someone will die with an asset, let's say an investment account for example, with a value beneath the value limit required to open a formal probate. As of right now, that monetary value is $184,500. How then do the legal heirs of the deceased person acquire access to that particular asset? Let's put together a hypothetical to figure that out. Dad dies in his Newport apartment in Orange County, and while going through his things, you discover a letter from Acme Financial addressed to Dad's estate. And you then discover at that time that Dad had an investment account worth $100,000. You think to yourself, I thought Dad burned through all of his cash taking his 25-year-old girlfriend to Reno. But it turns out that you may just get something after all. Unfortunately, the account is in Dad's name, and Dad did not create a trust, and Dad did not name any beneficiaries on the financial account, however. Accordingly, the letter from Acme states that upon providing a death certificate, tax ID number, and letter of administration, or any combination of the three, Acme will cut a check of $100,000 to Dad's heirs. Dad was never married, but he was survived by 2 children, you and your sister. You and your sister are Dad's legal heirs, but the probate limit is $184,500, so the court won't touch it. What do? You need to file a case in probate court in order to obtain letters and a tax ID, and the account is too small. How then do you access this $100,000 account? In steps a small estate affidavit. Per the probate code, when the gross fair market value of the decedent's estate is worth less than $184,500, successors in interest, or heirs, in this case you and your sister, may sign a sworn affidavit, think declaration, stating that you're the successors in interest to the Acme Financial Investment account, requesting that Acme deliver the account to you and your sister, and finally promising to hold Acme harmless of any damage that could result from transfer of the account from Acme to you. You then sign and notarize the document, submit it to Acme, and Acme sends you and your sister a check. Thanks, Dad. Now I bet you wish you would have visited him more often, don't you? That was a small overview on small estates affidavits. Hope you enjoyed it. Have a good one. We'll see you next time.
Hello, my name's Tony Tyer, and we're sitting here today with a client of ours named Al, who's going to answer a couple of questions about working with our firm. Al, what first caused you to work with our firm? How did you come to us?
Well, I came to you because your father has a tax business that when my wife was on this earth, we spent 35 years. And then we found out that his sons were involved in different areas of professional work after their graduations. And Tony was involved in this estate planning. And many years ago, I had a living trust done, and the first thing I found out was if I should die or my wife should die, get a hold of your attorney. Well, the attorneys that I wanted to get a hold of split their firm, and I had to go down to El Segundo by the airport, and I said, geez. And then all of a sudden I said, wow, Steve has a son who's in estate planning. And I went over to the office and started asking questions. Next thing I know, I had an appointment with Tony, and we started talking about redoing my living trust. And boy, oh boy, what a relief that was. No stress, and redoing the living trust, and the office was only 3 to 4 miles away from my home versus going over to LAX, and so that's how I came about to be with the firm.
Great. And then would you recommend our firm to other people?
Oh, absolutely, absolutely. You do a wonderful job. Nothing is professional language. It's all layman language, but still covers you, and you understand what's going on with this thing called a living trust or whatever you're doing.
Great. And then was there anyone specific with our firm that made your experience extra special?
Oh, just the convenience, number one, of where I live, but the idea of just being polite when you walk in the office, the idea of just being normal people, and you don't have to be professional, and don't worry about you're down in Wilshire Boulevard on 10th floor with high-rise attorneys, and that you're with logical people and giving you good advice.
If I asked you to describe our firm in 1 to 3 words, what would they be?
Absolutely, wonderfully professional at the common layman language. That's more than 3 words, but just wonderful folks to work with. That's 4 words.
Well, thank you, Al. We really appreciate that.
Well, I appreciate you, and boy, oh boy, if I can refer one, I'll refer 100 people to you.
Oh, thank you.
Trust
we really
me,
appreciate that.
and I mean it. I really do. Thank you.
Thank you. Hello, my name is Tony Tyre, and today we're going to be talking a little bit about estate tax. Estate tax, also known as death tax and inheritance tax, is a value-based tax which is $3.6 million in 2024. The current high exclusion amounts were created by the Tax Cuts and Jobs Act of 2017, which increased the gift and estate tax exclusion amounts beginning in 2018 through 2025. However, on January 1st, 2026, that amount will decrease to $5 million with a little protection for inflation. So all this really means, put quite simply, is if you're worth over the estate tax limit, estate tax would be paid by your estate. If you're worth under the estate tax limit, no tax would be paid. So for most of our clients, because they're worth less than $13 million individually or $26 million married, most of our clients do not pay estate tax. Thank you. Family law includes nearly every aspect of law. However, the purpose of this video is to explore some estate planning considerations in the context of divorce. This video is limited to estate plans drafted in California and divorces taking place in California. The reason is each state has different laws. If you are getting a divorce and only have one spouse who has a copy of your current estate plan, you should call your current estate planning attorney and secure another copy of the estate plan to ensure each spouse has a copy. Spouses often get nervous about requesting estate plans and tax documents from their respective professionals. However, you will need these documents for your divorce case. Next, you may want to revoke your living trust during the pendency of your divorce case. The reason to do this is to avoid your property passing to your ex-spouse. Please note that a revocable living trust will often require the signatures of both spouses to properly revoke the trust. In addition to working with a family law attorney, you should also speak with an estate planning attorney regarding the best way to proceed with revocation. Depending on your circumstances, the estate planning attorney who initially drafted your estate plan may believe there is a conflict of interest in advising you and your soon-to-be ex-spouse due to a potential conflict of interest between the two of you. You should speak directly with your estate planning attorney to determine whether or not there is that conflict of interest. And last, you should speak with your CPA to be aware of the tax implications of your divorce. Hello, my name is Tony Tyre, and today we're going to be talking about liability and trust. In our office, we commonly get asked, what sort of liability protection does a trust give me? And the answer is, it simply protects you from probate court. Reason you want to avoid probate court is that number one, it's very expensive. Number two, it takes a very long time. If you are more interested in liability protection, we typically recommend either having an LLC created for a rental property, or you just want to make sure you have really great insurance, both primary insurance and also umbrella insurance. Hello, my name is Tony Tyre, and today we're going to be talking about estate planning for young adults. A lot of our clients come in and ask us whether or not their college-age children need an estate plan, and the answer is yes. The reason is, once a child turns the age of 18, you as the parent need a power of attorney and a healthcare directive in order to have access to your child's medical records or in order to help your child make financial decisions. At the same time, your child should still have a very simple last will and testament just in case something were to happen to him or her. Hello, my name's Tony Tyre, and the number one thing that we want our clients to know is that starting on January 1st, 2026, the current estate tax law exclusion amount is going to decrease significantly unless Congress makes changes. If this does happen, the way that we estate plan may actually change. Our office will continue to keep you posted as we continue to receive more information regarding these potential changes.